So I'll warn the committee, don't loan me a pen because I walked away with the last committee pen and I had to go give it back.
It's okay. These pens were made for walking. I did. Anybody who's watching this deserves to hear us at our best. We're back live, and we're here right now with Matt Musgrave from AGC, which is Associated General Contractors of Vermont. And Matt's here to make some comments for the organization on age 66 questions, perhaps that we can answer. But Matt, you've met us all before.
Yep.
Welcome back.
Well, thanks for having me. And for the record, my name is Matt Musgrave, as you said, with the Associated General Contractors of Vermont. Just a brief intro to folks that are out there in cyberspace. We are a construction trade association that we represent road and bridge builders, commercial contractors, home builders. We have an electrical division, Vermont Concrete Ready Mix Association, as well as we operate the Project Road Safe program, which gives advice to fleet drivers and other people that drive commercially for work. We have around 16, depending on the day and the year, 16 to 20,000 employees that work within our different member organizations. And, one of the things that we pride ourselves on at the association is our dedication to keeping our staff safe out there in the field. We're the largest OSHA training facility that exists within the state. And I'll throw on top of that, we have a workforce development challenge. We have more people retiring every single year than we're able to bring into our industry. Last year, we successfully brought in around 2,500 new individuals to construction, which for men and women are high-paying jobs with low barriers to entry. It doesn't require a 4-year degree, although some choose to do that. Some choose to go to trade school. Some people just jump right in and go to work. So what brings me here today is the paid family leave bill that is here in the House. I, on short notice, did not prepare any written testimony, but I do appreciate you allowing me to come in and speak to this issue that we're dealing with today. My goal today is to ask a couple of procedural questions in terms of the bill, how it will look when things go out there, because, I've been up in the State House this is my 8th year as a registered lobbyist, and prior to that as a volunteer for a trade association coming up here and to speak. And it's very clear to me that when I see 103 sponsors on a bill, that indicates it's a priority for the legislature. So I'm not going to get into whether or not or how, why are we doing the policy, just some questions that I have to make sure that when you release this policy, that we have checked all of the boxes, because we are in fact becoming insurance agents at the state of Vermont for this program. So I just wanted to ask a few questions and point out some places that I could have maybe missed or misinterpreted how the bill works, or ways that we can improve the bill, and particularly dealing with potential fraud situations. And I know that you have Cameron Wood coming in from the Department of Labor who'll speak to fraud, but I just wanted to bring up one other element that I hadn't heard, I didn't see contemplated in the bill, and how does this bill relate to seasonal employment? So the general contractors, as do a number of other groups out there, I would name certainly like golf courses, summer camps, ski areas. They're all seasonal in nature. And in general, we all have drop dead dates that we know people are going into layoffs. When people go into layoffs, they generally do one of two different things. One, they are able to go in and collect unemployment if they're laid off. They have to follow the unemployment procedures and rules. If there's no callback date for the individual, they have to start looking for a job immediately. If there is a callback date that's after 10 weeks, they still have to start looking for a job right away and accept that position that's there. For contractors, we know this date and we know it well. It occurs in the middle of November. Depending on the calendar, it's anywhere between the 12th and the 19th of November. VTrans shuts our organizations down. We're not allowed to do road work. That's the end of our year. The year begins in April. So with the unemployment system as it is, there's a frustration for not only the staff, but there's also frustration from the employers that when if I'm an employer, I lay off someone that's a skilled excavator operator or someone that's a specialty contractor of some sort, knowing that because they're being laid off, because the state requires that we don't have work for them until April, we know that they're going to start looking for a job right away. And that's frustrating for our employers, although I'm not sure that there is an easy solution to changing that. So we will continue to live in that world. For the employees, it's the same feeling. I've been an experienced operator. I've been doing this. I'm 55 years old, which, by the way, is the average age of individuals in the industry. I don't want to go do something different. I don't want to go apply for jobs. I really am not that interested in taking half my salary. The good news is most of the people that do this work plan. They know that they have these seasons coming up. They know that they're going into the layoff period. And one thing that we don't talk a lot about in our industry is overtime. These people are not expected but volunteer to do a lot of overtime work where they're able to sort of set aside some money to get them through those darker months as we go through the winter where they can't get out there and work. Some of them go and work at the ski areas. Some of them operate lifts, some of them operate snowcats. But again, when you talk about a population of 16,000, and I don't know how many snowcats exist within the state, there is some challenges for them finding employment. So where am I going with this? Where I'm going with this is I look at the bill and I think that the bill is very well thought out when it comes to fraud. It seems to very much mirror policy that was worked on last year during, I guess it would be called the Grand Bargain version 2, when we came up with the 2020 fix for the unemployment insurance policy. Part of that, which originated, I believe, over in the Senate, was the language that's very similar to the bill that you have and the companion bill that's now been introduced over in the Senate for paid family leave. That bill definitely has some pretty harsh penalties for individuals that are involved in fraud. We agree that that's important for especially managing whether it's the unemployment trust fund or a new trust fund that we're creating here with the paid family leave program. Fraud is something that we care about. Because in order for these funds to remain solvent and for your actuaries to be correct that we're taxing the right amount of money, we need to make sure that it's being spent appropriately. So my concern when I look at this is reading over the text in the bill. It's very clear in the bill, both bills, that if you're on unemployment insurance, you cannot apply for paid family leave. What I don't see in the bill is preventing an individual that may know that they're going on unemployment in 30 days from applying for paid family leave and using one of the triggers for the paid family leave to essentially give themselves 12 weeks of full pay. And I want to just quickly say that I'm not casting any doubt on any individuals. I'm not casting doubt on any individual industries, but at the same time, on the other end, you could see for the employer where there's maybe a benefit. So for the employer, if they were able to have people go out on leave, they go away at full salary for 3 months. They don't have to go look for another job. So where I'm going with this is what we would like to see is some sort of, and Damian Leonard may correct me if I'm wrong, that this may in fact exist within the bill as written or in some other statute. We would be interested in seeing some sort of a guardrail that was set up so that we wouldn't trigger whether it was an innocent reason to trigger that or a nefarious reason. And an innocent reason could be, I went skiing and I fell off the cliff and I hurt myself. I'm actually an expert skier and that does happen. Occasionally you'll see me on crutches in this building. I'm also a mountain biker, but I'm terrible at that and I fall. So where I'm going with this, if you look at how mass layoff rules and the law works, is an employer that knows they're doing a mass layoff going into this November season is required to notify DOL and ACCD in writing 30 days prior to going into this layoff period, which is the right thing to do. What we don't have is a way to kind of, I think through this bill, if you're not allowed to collect paid family leave while you would be on unemployment, we would like to see something in there that says if you take off on 35 days before your planned leave, your planned unemployment or planned layoff, that you're not taking advantage of the system where you're taking money from ratepayers where you shouldn't be, where you wouldn't normally have been paid. I'm not sure if I'm being very clear with that or not, but
Can you say that again?
so what we don't want to do is pay people a paid family leave benefit where they wouldn't have been paid by an employer to begin with, which is in the same sense or vein as your rule on unemployment insurance. So I can't go apply for paid family leave if I'm on unemployment. I know that we want to make sure that people don't preempt the unemployment, or an employer tell people to preempt the unemployment and then take 2 months of full pay without having to look for another job. It's our opinion that that is a gap that's in the bill, and I think it would take minor language to cure that. So if you were supposed to be on unemployment or you're supposed to be seeking another job, you weren't taking money from ratepayers within the paid family leave system.
Representative James, then Krasnow.
Yeah, just a couple questions. I wanted to understand. So in the case of the mass layoffs that workers know is coming, did you say that they are not qualified to file for unemployment during that layoff period? Did I misunderstand? They do file.
So when you're laid off for your seasonal unemployment,
Yeah.
the first thing that happens is the employer will notify ACCD and DOL 30 days, and the employee, by the way, 30 days prior to their scheduled layoff. In that mass layoff form, it actually itemizes who is in particular going on layoff, other employment information, including their callback date. So they immediately, when they go into layoff period, go into unemployment. And because if their unemployment is scheduled to last more than 10 weeks, on week 1, they need to start applying for 3 different jobs. If they receive a job offer, they either have to take that job or they are prohibited from collecting unemployment.
So in that scenario, when is your concern that they would be trying to take the paid leave?
So we have a 12-week paid leave program. So you have 3 months. So if I theoretically, the way that the bill is written now, theoretically I applied in advance 5 days of receiving my notice that I was going on unemployment. I don't yet know, the commissioner doesn't yet know that I'm scheduled to be on unemployment. So then we have a situation, and this is where kind of the crux is for the employer. The employer doesn't want to be the bad guy or girl and police this issue. This is something that I think that the state needs to be the guard on, so to speak, because the commissioner is just not going to know if John Q says, hey, I'm going to go care for my mother, for example.
So and I'm sorry, I'm still trying to parse through. So a leave request would need to come supplied with pretty extensive documentation and then be approved by the new division.
Mm-hmm.
So what reason do you think a worker would give that would then need to be documented with like a note from a doctor or?
I break my leg 10 days before the 30-day notice goes out. I go in and I file for leave with the commissioner. I send in the forms from the urgent care that I went into to get my leg repaired, and I apply, but I don't suggest in my application that in 30 days I was going to go on unemployment anyway.
So if you obviously accidentally.
Right, and I want to take it away from like, this is not like a nefarious thing. It's innocent reasons.
So 5 days before the mass layoff thing is filed, you have an accident and break your leg and you use the note from the ED to file. That would then be in the system and the division would cross-check and find out that you're then on unemployment 5 days later, right? Wouldn't that be?
I think that's the clarification word.
Yes.
Got it.
Because
But that's not dire illness. That wouldn't be
That's
covered
serious.
under.
Yeah.
well,
Yeah.
a broken leg, if he were skiing, would be closer to fitting. That's a serious illness. It prevents him from working.
That
or
would be
injury.
disability though.
If disability exists, if workers' comp, and I see our HR person here behind you, Ashley, yes?
So
It's one of those funky things where it's going to be a little dependent on the person and the role that they fulfill, because you could have somebody who's, at a plant who has to stand all day long, and having a broken leg wouldn't work for that type of position. Whereas somebody who's in an office who's going to be sitting at a desk really would be able to work. So a doctor or a physician is going to also look at the job description of the individual who is either hurt or sick. So it kind of falls into this gray area on what role does this person fulfill and what is the injury or illness.
And I think that there's two notions of, and I know that this is covered. It still doesn't answer your question precisely, and we'll work with Damien. We'll ask Damien to review this testimony and see what answer he comes up with. But I know that you can schedule your leave. I'm going to have a baby on June 1st, and you can take care of that with the applications that are in place. Or you can break your leg and have up to 60 or 90 days to say, I missed 27 days of work. Can I get paid for those? And then it can run into the unemployment piece of it. So it really is, I mean, we can come up with scenarios forever to try to figure out, but we'll try to get an answer to that question and take a look to see if we can, see if there's, first of all, determine if there is a fix to be made, and then what it could be, because it is really, without going, I'm not going to put my head down right now and go through the broad sections, but they're there, and we can review them and then again get counsel's opinion on it.
Right. And I think it's like some just general assurances. And, when I talk about the unemployment system, this is a great example of one of the challenges that employers face when you're faced with fraud in this. And again, let me just, before I say anything else, this is not, let's look at this in a legitimate trigger method and not someone misbehaving, so to speak. So 5 days before my notice, my mom gets sick and I have to take care of mom, or, a legitimate trigger. So the unemployment system in this is hard to track because a lot of the, so to speak, enforcement is placed on the employer to go out there. So here, a good example that we ran into most recently when COVID lifted and the unemployment, lifted to what degree it's lifted, and the unemployment system changed and the work search requirement came back. It was a real challenge because when an employer, and this was, I mean, you could call it anecdotal, but I would say hundreds of phone calls my office received of people that were applying for jobs, being offered the job, never accepted the job. And then it's on the employer at that point to call up DOL and said, I offered a job to this individual who's on unemployment and they refused to take the job. I mean, we're in such a small state that we have 1 degree of separation in Vermont, and for employers, that's a real tough place to go if all of a sudden someone's afraid to come in and apply because they're afraid you're going to go call the state and report them. So it becomes a kind of a sticky situation to put the employer in as enforcement on these pieces, which is why, looking at the complicated nature of paid family leave in that sense that we're talking about now is the reason why I bring it up.
Representative LaBounty, then.
Thank you. I know we were kind of talking about when there is going to be a layoff, the person is noticed, but let's say the person's laid off and he's got 10-week layoff, he's got a callback date. 2 weeks, he's out skiing, he breaks his leg. Well, he definitely can't keep collecting unemployment, I don't think, because he's not eligible to work. So he would I guess my question is, would he be able to qualify for this? Number one.
Yes, because he would have paid into presumably if he qualified, we're calling them qualified individuals. Yeah. So if he's paid into the system for 2 quarters out of the last 4 to your seasonal piece of it, we've been using ski areas as an example, if somebody's working in January and somebody's working in January through whatever, and then, November, December. But the answer would be yes, if they can't work and it's a serious enough injury, if they become a qualified individual, they would just go off unemployment and take this. That's my interpretation.
Yeah, that was mine, but I just wanted clarification.
Again, ask those questions again.
And the other, just to follow, to follow up, when an individual is applying for work, and I've been out, for a while, so I can't remember quite all of it, but if an individual is doing job search and he gets an offer, but let's say it's a minimum wage job,
Right.
and he's making, let's say he was making $1,500 a week or $1,200 a week. I thought there was a threshold where he didn't have to accept the job because it was so far away from his, what he was normally getting. So, I mean, I could be getting the maximum of unemployment, and I think it's like in the $600 range.
Right.
$655, I think. Well, if I'm offered a minimum wage job, I'm not going to be anywhere near that.
Right. Well, they use I think the legal term that they use in the Green Book is suitable work.
That's right.
Suitable work would be defined as, and that would be a Damien definition, but my layman definition would be that suitable work is a job of a similar type and pay.
Yeah.
So like, for me, it would be an association executive lobbyist person.
Yeah, I remember years ago when I was on unemployment, it was like, I think it was like the first, month, you didn't have to accept a job that paid less than 10%. And then it was like 20% of your pay. And then the next, it was 30%. But I think that's probably changed.
Yeah. I think that went away maybe in the grand bargain of 2008.
We'll see.
Which is a whole, that's the 3-hour course I could give on the grand bargain.
Thank you.
So I think there was another question.
Yes, Representative.
Yeah, thank you. And so I was similar question, I was gonna say a similar thing, we're on the same, look, we keep being on same frequencies here. And then the other thing was just, I could have sworn we had testimony that spoke a little bit to this, that said something about if it's all employees, so therefore if the job security and or the job safety, whatever it's called, and the pay could only be accessed as long as the position was there. So if it's a seasonal position, it would be my understanding that when that position is scheduled to end for all of the employees, that the benefit would also end because it ended for all of the employees.
No.
No?
No. The benefit, if you're not working and you're not receiving unemployment, something happens, you become a qualified individual to receive the right amount.
Mm-hmm.
If you've paid into the system for 2 quarters out of the way this is proposed, it's 2 quarters out of the previous 4.
Right.
So, but it doesn't, because my understanding is that if something happens to you, that you become a qualified individual, you either have to help your family, you can't look for work,
Injury.
or something happens and you have a baby and you need to take time, you're not going to be able to go back to work. You could become a qualified individual.
Yeah, but if the position doesn't exist anymore, I thought there was a caveat about the existence of all of the employees.
There is a caveat. Let's look at it.
Okay, sorry.
Let's just.
I have more questions now.
No, it's fine. It was just, I just remember hearing some, because I was having similar questions about temporary employment and seasonal employment.
If a person is on unemployment, they're not in a position, there's no job protection because they're not in a job.
Right. Well, no, I'm not talking about unemployment. I'm talking about, in this scenario, if someone were to try to access the medical leave for an injury prior to gaining unemployment, right? And so the reasons to receive unemployment, if it's a seasonal position, because you can't know, right? And you can't be at any fault of your own in order to receive unemployment. And so I'm just trying to think, you wouldn't, if it's a seasonal job, is the only way you would know that you were going to be getting unemployment soon, right? It's a temporary position. And so with the paid family medical leave, I'm gonna find my notes, but I know there was something about a stipulation where if the positions did not exist, then also,
No, I know what you're talking, I don't know where you are on the page, but I
yeah,
know what you're talking about, and we'll go back and look at
Okay.
that. We'll just go back.
something along those lines, I think.
Yeah.
Yes,
No, we'll
okay.
go back. There's a whole section that has to deal with this area of conversation.
Yes,
So,
okay, thank you.
I just want to take a half a step aside so that, can you just spend a couple of minutes, not 3 hours, thank you. If you could spend a couple of minutes and talk about, we haven't talked a lot about employment stuff in this committee beyond this. And I haven't talked a lot about employment when it comes to seasonal layoffs. So my experience from many, many moons ago in this committee was about granite workers who also had a seasonal position, but they are union jobs and but they had a seasonal layoff and they had so can you just talk a little bit about what it means to have a company, a business where you're as a business owner, you're gonna have to budget in your extra unemployment because you're using it. So I imagine the UI rates for employers can go up quite a bit. And yet, when I see the reports that come out of the Bureau of Statistics, I don't see like going from 2,000 people receiving unemployment checks to 18,000 people receiving unemployment checks as an increase in the unemployment rate in December, January, February. So, and do you have a
I
clarification?
do. I appreciate you bringing that up because I don't really understand this at all.
The seasonal
Yeah,
unemployment?
and
Well, that's why I'm asking, because-
what's the advantage of that versus, what's the advantage of laying everybody off at the end of the season versus keeping them on full-time, like teachers? And I don't really understand this.
Yeah.
I apologize for my ignorance.
I'm only giving them like 3 to 4 minutes.
All right. So this happened a long time before I came along. So I couldn't tell you the history as to why, but I can explain to you that we're unique in Vermont, and the northern states are unique in this piece because we freeze. So we're unable to do roads and bridges. We're unable to dig in the ground. We're unable to build buildings. There are safety hazards. If you were outside on Friday, you could imagine what it would be like to be dangling on a bridge if the concrete would set. So these jobs are also highly specialized. So whereas we don't have summer school per se, so there isn't really an option to do that. And I think the teachers within their collective bargaining agreements, I think have set up a program for themselves in the summertime. And so the way that it works with construction is simply because we can't go to work. People in this building, people in our organization have come to the conclusion that the best solution for these individuals is to go into the unemployment system and seek a new job. So really to say that we're putting them out onto unemployment and they're going to stay there isn't necessarily how this works because of the way that the law works. So for us, and in the multiple different facets of our industry, this is just a reality of how it works. Is that there is no work for them, there's no income for the business. These construction businesses, you see huge price tags on them, right? You see multi-million-dollar roads and bridges go up, you see the price of housing. The profit margins are very tiny on these. So when you look at a construction project, about half of the project is labor, about half of that is materials, permitting costs, and other administrative fees. And then on the average construction project, if you see a 1 to 5% profit margin, that's, if you saw a 5%, it's an amazing day. I can tell you that contractors over the last 3 years, well, maybe 2 years since this inflation have been on the other end of it. There's been no profit. So they can't afford to keep these people on the payroll unless they're actually doing productive work that brings in money for the company. So that's why there's a layoff. It's not a heartless situation where they say, get out of here. It's my company does X and X can't be done.
Yeah,
So
but
we
why-
have to let you go.
Why would you lay them off versus just acknowledge that the time frame for this job is X?
I don't believe that there are many career fields that are out there that would provide a paycheck for not producing stuff that's happening. And when the winter happens and they can't do their work, there's only so much maintenance you can do in the garage. There's only so much work. You have specialized mechanics and such.
You have the ski industry or other winter industries that I just don't.
Well, that's the purpose of the
Paving company
unemployment.
isn't going to pave the mountains per se. And so if they're not diversified, also, if they ended their employment contract, I've been working
I know.
on a farm. And I signed a contract in May or June, and it says that my employment ends 3 days before Thanksgiving, when the last turkey is harvested. And so that's a contract job for me. I didn't get unemployment. And so for these companies, correct me if I'm wrong, but for these companies, when you have an excavator who's 55 years old, been with the company for any length of time, and the company wants to keep them, this is why there's a callback date.
Mhm.
And again, this happens in certain industries. And this is why I'm bringing it up, because we haven't talked about this in terms of, it's different than teachers because teachers have contracts and, teachers can extend their paychecks through June if they take, through September if they take less during September through June. So I'm just assuming that it's not an illegal or unethical or immoral use of the unemployment system, but it's the way that the companies can possibly keep employees. But then you get to the point where you said if it's over 10 weeks, they have to start looking for work anyway.
So I'll give you the 3 minute.
I don't know if
That works.
But I don't.
I'm just asking what the advantage is to one over the other. I
So.
can wrap my head around the fact, but I just want to know why.
So let me go back. This is a bigger conversation, but I will bring it into a 3 minute piece. So when you start a construction company, if you start any company, you have to file, if you have employees, you have to file with DOL, and you have to pay unemployment insurance per employee. So the unemployment insurance rate is based on the minimum taxable wage, which I believe is around $15,000. So each employee has a $15,000 approximate price tag that follows them, and the employer is taxed as a percentage of that based on their experience points over here. So you have your taxable wage base, and then you have a sliding scale from really great employers that never lay anybody off or fire anybody to the highest level, which are generally the seasonal layoff organizations. So the seasonal layoff organizations are paying in a significant amount more money into the unemployment system than, let's say, someone that owns a small business that the same people have worked there for years. They're at a very, very low premium payment. So the contractors pay a very, very high premium payment. And that's based on the fact that they have seasonal layoffs. It's not because they're generally bad employers. We actually pride ourselves on the way that we take care of our people. But the system is set up so that people that take the most out of the unemployment system pay the most back into it. So the way that it works, and to your point on the ski areas, the way that the unemployment system works for people that are laid off for more than 10 weeks. If I laid you off for 9 weeks, I could give you a callback date on the 9th week, and you would just collect unemployment benefits. You don't have to look for a job. If it's 10 weeks and 1 day, that very first week that you're on unemployment, you have to start applying for suitable work. And so that is a self-fulfilling prophecy to get those individuals out there that are on these long-term applying for jobs, running snowcats or operating the ski lift or working in a bowling. I mean, wherever they can find work in the winter. So there is an incentive or a disincentive to laying people off for a long period of time because of the work search requirement, which is why I'm somewhat challenged by someone could trigger paid family leave prior to going on unemployment, meaning they weren't going to be paid anyway. And that's a frustration for both the employee and the employer during that period of time.
Thank you.
I hope that was a 3-minute.
It was three more.
But it is set up to take that people that are playing in the sandbox are paying.
So I think this is just an example of the many nuances that exist in our work. So just keep that. I mean, we're not going to understand it all right now, but I do. So Representative LaBounty and then Parsons had questions.
Well, I just want to make a couple of comments. One is that those employees in the construction trade or in the granite trade know that they're going to get laid off, so it's not a surprise. And number two is when you're looking at ski areas, and I know that's what we've been looking at, well, there are some people that this is what they do in the winter. They do the ski areas, and then in the summer, they might do landscaping and stuff. So now they're planning on going back to the ski areas. Well, if you take all of these people that are laid off in construction and everything and trying to force them to go into the ski areas, well, where are these people going to go? So you have that. So, you have that. And not only that, but now you got to train an individual, to do that job. And if that individual gets hurt, and now I'm and I have a granite core and this is my cutter and he's hurt because he worked up on a ski area, I'd be a little PO'd.
So I just, so I agree. And, we really need to support our ski areas. That's how we become sane on the weekends after work like this. So we do support our ski areas.
It sounds like an athlete who, made a mistake by trying to cut their own hedges and cut their hands or, whatever.
Well, and you made the point of, looking at the ebb and flow of people on the insurance program, the unemployment insurance program. It's because in the summertime, it goes like this. So you're going to likely see a pretty similar line for that. And they come off quickly, hopefully.
Representative Parsons.
Thank you. So in the beginning, I was fully understood. I still do. Throw that caveat in. Still do. Until I heard the part where if you're on unemployment, this still applies to you as long as you're on unemployment. You had said, somebody had mentioned if you go on unemployment and your family member gets sick and
But you can't continue receiving unemployment.
right, but you'd switch to this program.
You could.
You could
switch to this program.
Which would kind of negate your entire.
I mean, if you're asking me the question, do I think someone should be on this program when they wouldn't have been working because they're on seasonal unemployment? My answer is I don't think they should be paid under this program because that's not what this program's designed for. This program.
But again, if you were in a program where, if the program, again, I think the example was brought up was if I'm on unemployment and I'm supposed to be looking for 3 jobs, I'm supposed to be applying for 3 jobs a week and take whatever suitable job comes my way. If I'm out skiing or if I went to the doctor and had a CAT scan and they found a lump and I couldn't work, then you would say, I can apply for this program. Because God knows you're not going to be applying for 3 jobs a week. But you still have to go through the paperwork. You still have to go through the process. You still have to say, I'm receiving unemployment now and need to receive this now. Because of course you are limited in the amount of unemployment you can receive per year as well, right? I don't know if it's 13 or 26 weeks. I don't know what it is now in the way the market is. But at any rate, I want to stop here. Hold these questions.
Thank you.
Yes, Elizabeth.
I have a committee question.
Yes.
Could we possibly ask to have Damien address, what about the legislature?
Yes, if we can find a rabbit hole deep enough.
I touched on that when I asked about our government employees who are not in a union included.
Our status as employees is really closer to the gig economy than it is
Yeah.
to anything else with the lack of benefits and the limited amount of time. Actually, before we go, so Matt, thank you.
Great.
Thank
And I
you.
think Cameron will be able to answer you whether or not someone who's disabled can collect unemployment. I would venture a guess they can.
Okay. Because then there's short-term disability.
Right, I was gonna
So
say.
there's short-term disability, could be workers' comp, could be. So committee, before we go, I want you.
Thank you.
I want you to just nosh on this overnight. So we have a bill that has, I think, outside of the last section, which is the dates that things would go into effect, effective dates. We have a bill here that's in front of us that has 4 sections. It has definitions, it has a section on the paid family leave insurance program. It has a section on PFLA, it has a section, which is the unpaid section, and then it has a section on safe leave. My concern with the structure of the bill right now, first of all, we haven't gone through the definitions because we didn't want to take a nap. But we have to cover them at some point. But I want to throw out there in terms of I'm making sure that we understand what's going on in the bill. To me, what's going on in the bill is that we are changing the underlying system, the leave system, the 12-week leave system. That is like, and then the insurance is being laid on top of that. Do you follow the imagery for that? So here is an existing program that we're changing. And then we want to add a funding mechanism to that. And then there's the safe leave, which comes in on the side, which is adding to the unpaid leave job protection piece, all right? And it's asking for more job protection, but it's being added to the unpaid section. When we were, Robin and Kath and I were talking about this yesterday, it's like, if this were a story to be told, should we be, in terms of understanding and explaining this bill to other people, the question I have for us to answer, not in 2 minutes, but is to say, should we be telling the story from the fact that we're changing the underlying piece, which is the unpaid leave? We're adding this safe leave piece to the unpaid job protection. And then the third section would be the paid section, because we're layering that on top. And then we would go to definitions, because it's like the index of a book or something, we're just looking at. So it's just something that we were talking about and toying with in terms of, and I would consider that in essence a technical change that doesn't have anything to do with what we're going to talk about specifically for each of the sections. But it's a technical change, and it just, like, I'm calling it a storytelling thing, which perhaps isn't common in our work, but if we're explaining this to other people on the floor of the House or to anybody else, is it better to start with the base and then build onto there, rather than here's this, because the insurance is so totally related to the 12 weeks of existing leave. It's new, but it has to do with what's already in place. So just think about it. We'll talk about it tomorrow.